during the trial when you came on board?
I deal with each topic below, but it's worth initially making 2 points.
The project
First,
went to air in
Mr.
February
Orbach accepted in
2021,
cross-examination that he
and
hated
unless
his
you're
former
living under
colleagues
a very
and
heavy
friend,
rock or had been stuck
Spotlight producer
overseas
Mr.
during
Steve
the
Jackson
pandemic, and
blamed
even
him in
then,
part for the fact his
you would not
contract
have
at the Seven
failed to have been
Network was not
aware of
renewed.
this
Given his cast of
allegation or
mind and
this,
his more general
from the
resentment
media's
as to how he was
perspective,
treated
story,
over the Spotlight
made it
program,
a
it
very
is unsurprising he has an animus
important
towards
matter
the Seven Network,
for
and this
us
was
to
manifest in his evidence and in his manner
act
of giving it.
for Bruce.
His resentment was palpable
without having
upon
met
the
him, without knowing
viewing of the
anything about the
wanton and
case.
vaguely disturbing destruction of what appeared
As
to
at
be
the
a
time we were asked
perfectly
to
serviceable set of
act
golf
for
clubs.
him,
It's unnecessary to make
certainly
factual
my
findings in
perception was
relation to
that
many aspects of his evidence,
this
but
was
one will
Alice in
generally be
Wonderland.
cautious in making
Sentence
findings
first,
based upon
or
incomplete
verdict
evidence
first,
and
trial
resting
later.
solely upon the word of a man
Because
motivated by such rancor.
there was so much material out there that
Secondly,
was
and
just
connected to
simply,
my first point,
he's
the
guilty,
evidence
and we've just got to go through this process
the
of the
evidence of
trial.
Mr. Orbach travelled
I saw
beyond
that as
seeking
a
to impeach the
significant
credit of Mr. Lerman. He
undermining
laid
the
the
rule of law
allegations
and
on
the presumption of innocence
thick against a
and due
variety of
process,
persons, somewhat like the
and
paint in
I
another
wanted
work
to,
of his namesake, Frank.
be part
One
of
of these allegations was that he was instructed,
an
apparently
attempt
implicitly
to at
by a
least give
solicitor,
this man a
Mr.
fair
Richard
trial
Keegan, to delete
in
any
the
materials
face
that could be
of
damaging
what
for Seven.
I and many other
I
people
reject
had
this assertion.
considered
It is unbelievable
was
on its
such
face.
adverse publicity that
As
he
to his
could never
allegations
actually
of
get a
improper
fair trial.
conduct against his erstwhile work colleagues, they are irrelevant to the facts in issue,
Ms.
except
Wilkinson
in
had
one
not said
limited
the things she said
respect.
at the Logies, and the trial judge had not adjourned
I can
the
deal
trial
with
for 3
Mr.
months.
Orbach's evidence of
I
profligate
genuinely
behaviour
believe
very briefly.
Bruce would have
He
been
gave
convicted.
evidence consistent
What
with
happened at the
contemporaneous
Logies
documents
and
and
what was said
uncontradicted by
is
any
the matter
evidence in
of
reply by Mr.
some
Lerman that he became Mr. Lerman's
contention and
babysitter or
discussion at the
minder
inquiry, so
as
I
the
won't
Seven
say anything
Network
about
worked to secure an
what was
exclusive
said,
interview
but
with
it's a matter
Mr.
of
Lerman.
public record that as
At
a
some
result
stage
of
it appears Mr.
what
Orbach
was
was
said,
discomforted in being
we
placed
made
in
an
this role,
application
but he
for a
nonetheless
temporary
performed it.
stay.
Sometimes it appears ardently.
It wasn't fair,
I assume that Mr.
on top of
Lerman
everything
thought
else,
his
for
joint
Bruce to
activities
have
with
to
Mr.
face a
Orbach would be
jury
kept
a week
private.
after.
The specifics
On
are
one
unedifying
interpretation,
and it is unnecessary
there
to
were
make
public
granular
statements
findings.
again,
In the end, it is fair to
basically
conclude that Mr. Lerman was
saying
less than candid in his account of the extent
Ms.
of the benefits he
Higgins
received prior
is
to
a
and
true
in exchange
victim of a
for
true crime,
his bargain to
and the trial is
participate in
just
giving
a
exclusive interviews to the Seven Network.
formality. So we said we
It
needed
is
to
fair
have
to
some
remark that
time,
the
we
evidence
needed to
reveals
stay
is that some
in
of
order
the
to put some
pre-compact
distance from that
inducements and
speech
consideration
in the
flowing in
minds
the
of any
direction of
potential
one
jurors.
contractual counterparty was
And
of
the
an
Chief
unorthodox
Justice
and
agreed,
undocumented
and the
kind.
trial was put off for 3
But
months.
given
If
the
it
other
wasn't
man's going to
for
credit
Ms.
in
Wilkinson's
this
speech,
case,
we
it
would
is
have
an
gone into that
inconsequential
trial
point.
without so much
The second
material that
point
we
has more
subsequently came
significance.
into
The
possession
reasons I
of,
set out in
either
detail,
through chasing up disclosure or
and
chasing up
notwithstanding the
subpoenas,
fact that I'm not some
that
sort
was
of roving
integral
law
to
enforcement
properly
official, and that
understanding
any alleged
and
breach of the Herman Street
challenging the
obligation, if it is to be
complainant's
pursued,
allegations.
will not be by me and will not be by this court. I am satisfied that
There's
Mr.
no such
Lerman
thing as
made or
jury
caused to be
whispering.
made false representations
I've done criminal
as to the
trials, I've been
topic of
involved in them
providing
for over
access
30 years, and
to documents the subject
I've
of a
never
subsisting
known
legal obligation
what a verdict
to
would
the Seven
be.
Network.
But it's almost like
Ms. Higgins,
something that everybody does. We
it is
spend our
necessary to
entire
assess the
lives
credit of
and the
Ms.
trial
Higgins circumspectly.
dealing with
She
admissible
is someone
evidence,
who has had
probative
the
evidence,
intense, uncritical
but then as
support
soon
of
as the
some,
jury
but
goes
has
out
also
to
been the
consider its
subject
verdict,
of widespread
we all think
social
we're
media
experts
abuse.
at determining because
As with
someone
Mr.
raised an
Lerman,
eyebrow
I'm conscious
or
that
sat in a
giving
different
evidence would
seat
have been a daunting
or
and
giggled
stressful
some comment,
experience.
that
I'm in the
we know what they're
unusual
thinking,
position
and
of
it's just-
receiving submissions from a witness as
just
to
not
her
true.
credit directly.
I was always
This
concerned
came
that
about because I was
of the
anxious to ensure
publicity,
procedural fairness was
because there were
provided
so many
concerning
people who
submissions
were
made
exposed
as to the falsity of
and
some
influenced by
of certain out-of-court
the
representations.
pre-trial publicity, that we would struggle to get
Ms. Higgins' submissions extended beyond these
necessarily
out-of-court
12
representations,
unbiased,
and there was one
unaffected
point
jurors.
also made by the respondents
and in
that
some
is worth
respects that
mentioning.
was borne out by
That is,
the number
it is
of
said that to the extent
people in the
that peripheral
jury pool who
so-called
quite properly,
peripheral details of her
when the Chief
reconstructed
Justice
memory
asked
were
that
wrong.
anyone who thought they
They
might
do
have
not
some
reflect
pre-existing
dishonesty,
bias,
even though they
either
may
for or
raise an
against
issue as
the
to
complainant or the
reliability.
accused,
As to
or had
reliability,
attended
one
the
must
March
not
for
take
Justice
account of the
or
well-known
subscribed
general
to
one must
particular
take account of the well-known
views
features
about,
of human memory,
sexual
but also
assault,
the mental state
or
of Ms.
even had
Higgins
own
and the
experiences
well-known
that meant that they
specific
could
effect
not
of trauma, and in particular
bring
sexual
a
assault
fair
on
mind
memory.
to the role of a
This
juror
submission
to come
has
forward.
merit up to a point,
A lot of people did.
and it is informed inform my consideration of
but we
important,
were
indeed critical
never
aspects of Ms Higgins'
able to be
evidence.
sure that
But as I will
some of the
explain, I'm
people who didn't
comfortably
come
satisfied
forward
that a
may
number
have
of the
had
credit issues
strongly held
arising from a
views
fair
and were
assessment
going
of
to
Ms
not come forward
Higgins
because they wanted to
cannot be
ensure
minimised in this
justice
way.
as they perceived it would be done.
Those studying political science in the late 20th century were inevitably introduced to
I
the
gave
work of Hannah
evidence
Arendt, who discussed the
in
importance
relation
of public
to
truth
my
while coining and
perceptions of,
explaining the notion of organised lying.
concerns about
There is a significant difference between the distortions of
crime
Mr.
commissioner
Lehrman
having,
and Ms. Higgins.
walked in and
In
out
the
of
case of
court
Mr.
with
Lehrman,
Ms.
the
Higgins.
untruths
It's
were
one
all
of the
over the
terms of
shop,
reference, and it's
being a form of what might be
one
described
that
as
I
disorganised
anticipate
lying.
there will be evidence about.
Whereas the
I
untruths
did
of
not
Ms.
have any
Higgins, A,
personal
can be
dealings
placed
with,
in two
and I certainly
temporal
have not got
categories.
any
B, were
beef
in the
with,
latter category
the
quite
Victims of
organised,
Crime Commissioner
and
or
C,
that
within both
office,
categories
or
generally had a
the
common thread.
important
In 2019,
work
it
that
was
they do
to
in
paint
supporting
aspects of her
people who
conduct in a
are
better light at a
asserting
time when
that
she
they are
did not
victims
wish
of
to
crime.
pursue a complaint.
The problem in this
But
case,
by 2021
it's
and
not just
afterwards,
my perception,
most were
it's
part of a
one that
broader
I
narrative
know a lot
or
of
theme
people
that
have
she
shared,
and her
is that
boyfriend wished others to believe, and it
by
appears others
walking next
wanted to
to
believe.
Ms. Higgins into court every day,
Unsurprisingly, counsel
as
for Mr.
the
Lehrman made several
statutory
detailed
office holder
attacks on the
of
credit of Ms.
position of
Higgins
the
in final
victims of
submission,
crime.
but no distinction was
That would be
recognised between the
videoed
two
every morning.
periods and
It
the
would be
different
in the
contexts
papers
I
and
have
the news
described.
that night. It carried with
Ms.
it
Higgins was
a less
described
than
as a
subtle
fundamentally
and a less
dishonest
than
witness, such the
subconscious
court could not act on anything
inference
she says
that
without
Ms. Higgins
independent
was in fact
corroborative
a
evidence.
victim.
This
It
submission
was
was
about as
developed
subtle as
by asserting her evidence has been
Ms.
so discredited
Yates had
and
walked in with a
and has been shown to be so
T-shirt,
manipulative
wearing a T-shirt saying
that the
Bruce is
court
guilty.
cannot safely rely on anything she has said.
If I was ever going to write a book about this experience or this case or anything about
Like
it, I
with
think I'd
Mr.
call
Lehrman,
it
I will not
throwaway
evaluate her
phrases,
evidence as to what
because
occurred in the ministerial suite
really
now, but it's
does
convenient
sum up what
just to note
this case
some
has
points made
demonstrated,
by
in
Mr.
my
Lehrman.
view,
In fact, there
relation
were
to
10
what was
primary
more an
points made in the
insidious and
submissions, which I deal with really in the course
which
of
is
making
this
findings of
conflict
fact.
and
I'll
this
only
tension
mention
and this slow
two,
bracketry
which I think are
between the
inconsequential
presumption
at
of
this
innocence
stage.
on the one hand,
Mr.
and
Lehrman submitted that
believe
Ms.
all
Higgins'
women
draft manuscript was
or
full
in a
of
sexual assault
inaccuracies and
people don't make
inconsistencies
anything up,
with her evidence,
and
her
to the undermining
unsatisfactory
of a
excuse that the book
innocence.
is crap,
Due process
notwithstanding
and
she
the
was
presumption
under
of
a
innocence
contractual obligation
are
to
not
tell the
throwaway
truth in the
phrases.
manuscript reflects
They are
upon
the
her credit.
cornerstones of the rule of law.
And finally,
And
Mr. Lehrman relies on what he
we wanna
described
have a
as Ms.
debate
Higgins'
about
misleading and dishonest claims about a lack
what
of forensic
the
analysis of
presumption
Mr.
should
Lehrman's
be,
phone
whether
and
there
her
should be
speech
an
to
onus
the
of
media
proof, whether
after the
an accused
mistrial, when
person
she
should not have a
well
right to
knew that
silence.
Mr. Lehrman's phone has
Those
been
things should
analysed
actually
by the
happen in an
AFP.
informed way, publicly,
It's
rather
convenient,
than
as I say, to deal with
this
these 2
insidious
points shortly.
suggestion that it's
They are not
that's
of
what the
real
system is, but
significance.
it's not
As
good,
to the
it's
book,
not right,
as the
and that's
saying
really
goes,
just
an
not taking any
autobiography
notice of.
usually reveals nothing bad about a writer except his memory.